The Impact of EU Legislation in the National Legal Systems by Giancarlo Pesac. The cure for boredom is curiosity. There is no cure for curiosity. Dorothy Parker. For businesses and individuals, the impact of the EU legislation, it is essential in order to know what are the rights and obligations. There has been a lot of tensions to determine to what extent the EU legislation has an effect in national legal systems. I'm going to first of all analyze the impact of the EU law and how efficient it has been to implement their interest, even though it may collide with the interest of national legal systems. I will always cover as a purpose of study the level of acceptance that exists in the member states towards EU law implementation and its impact in national legal systems, with two particular examples where there has been tension between member states and EU law. First of all, it is essential to determine what is the purpose of the European Union and European Union law. According to the Street Journal in an article by Anne Stratters, a prestigious journalist, EU purpose is described as following based on what the official European Union page determines. The Union's purpose is to promote peace, establish a unified economic and monetary system, promote inclusion and combat discrimination, break down barriers to trade and borders, encourage technological and scientific developments, champion environmental protection, and among others, promote goals like a competitive global market and social progress. Now, according to a financed page from the University of Law, allaboutlaw.co.uk, the definition of EU law is as follows. EU law relates to a wide range of different matters, from agriculture to competition law. As the European Union grew in size, the idea was to create a level playing field and harmonize the laws across the Union regarding certain matters, mostly trade. allaboutlaw.co.uk. It has deliberately expressed the intent of creating integration between nations with the purpose of peace and progress, and legally harmonize the laws across the Union with common interests. In this context, the implementation of EU law seems to be with a common positive-oriented goal, but many fears it may in too much. In 1988, the Commission President at the time, Jacques Delors, stated a real famous prediction on the impact of EU legislation on the member states, claiming that in 10 years, 80% of economic and perhaps also social and fiscal policy making would EU origin. 25 years after the prediction, we see a lot of challenges for this to become a reality, and this statement has risen the studies of scholars and member states. As it will be explained in more detail, there is a massive fear concerning the loss of the sovereignty of a state by EU legislation, and because of the fact that higher EU law to some extent has intervened with national legislations by blocking the possibility to revoke or amend existing national laws of member states, because they do not coincide with their interests. This has caused a lot of concern and acceptance of EU law in each member state, and it has created the need of debating the extent to which EU law will be allowed to impact in national legal systems. Two important examples where we can see to what extent this issue has had repercussions and it related to important political decisions is the relationship of this particular issue with the causes of the separation of the UK from the European Union. Also remarking example, even before the separation of UK from the European Union, there was an act in 2011 which was intended and used to restrict EU legislation as dependent of national legislative acts. As well, Germany has been facing political controversies, with similarly though on the fact of what extent can EU law can impact and effect on national law. According to Professor of EU Legislative Studies, Ton van den, German constitution was used to regulate the power of EU. The German constitution regulates not only the transfer of powers to the EU, but also addresses the consequences of legislative authority of the European Union for the national Parliament and the Bundesländer. Even though there are a lot of studies trying to deliberately express the impact of the EU legislation in national systems, it has not been properly measured or quantified because most research seems to contradict each other in describing the percentage affected by EU legislation. According to Professor of EU Legislative Studies, Ton van den, the way of quantifying the effect of EU legislation impact on national system is not properly studied because most studies focus in just specific policy events, and the EU legislation impact may vary from one policy area to another. We can say there has been initiative to restrict immigration in several number of states which have been blocked by high EU law. One particular example of EU law interference with national law is cases when the member state is already a pre-existing national legislation that complies already with newly adopted EU legislation, and member states are prevented from revoking or amending this national legislation in possible ways that are not in the interest of EU law. I will try to express this matter in the legislation of criminal law. In the persecution of criminals among member states, it is important to emphasize that even before the European Union, we still had a collaboration within nations to be able to persecute and make accountable people considered criminals by a particular state. The Articles 82 to 89 TFEU state that the cooperation in criminal matters need to be settled on a principle of mutual recognition and the regulation of cross-border situations. The principle of recognition that states that the border of each member state should not be an obstacle to persecute and apply the corresponding legal actions to its persecuted. This law is completely direct in impact in national legal systems because of the fact that it needs all member states to contribute to its cause. There have been intents to debate the implementation of this law, which have been blocked by higher EU law. Another example of a direct impact in national legal systems is European arrest warrant. It has a huge impact because of the access to operate outside an individual member state, which is basically the continuum of a criminal warrant outside a member state with the collaboration of each member state. The key in here is the mutual trust between each member state to cooperate with the authorities and have a collaborative approach towards the persecution of considered criminal activity. There are some clashes in this matter because some believe that the fact of just belief based on trust that someone is being persecuted by other member states can diminish the fundamental rights of a member state to oppose the decision of another state's decision. Migration is a huge relevant topic in which there is a clear impact of EU law in national systems. It is important to emphasize the fact that immigration has always been a matter of huge controversy, where you have a lot of citizens with different contrasting opinions. There is a huge evolution in almost all member states of Europe towards the acceptance and facilitation of immigration, which EU law has hugely contributed to. The purpose and direction of the European Union law clearly shows the interest to facilitate the possibility of migration inside the member states. According to Noel A. and N. Cascone in the Great Insights magazine, there has been a lot of challenges with the acceptance of the effective impact of EU law in the matter concerning immigration. The challenge still is the fact that the acceptance of this is still debated inside member states, because EU law has impacted the national legal system's power in the matter of its autonomous decision. There is still a lot of concern and unacceptance to be worked with in the next years with the member states in order to allow EU law effectiveness in its program schedule. In conclusion, we can see that the European Union law has impacted national legal systems towards a direction that it has recognized to be more in congruency with EU law original main purposes. It can be said that exists huge tension that is subject of controversy by member states regarding to what extent EU law can impact legal systems, where the main concern is maintaining legal control as autonomous nation, and also in the two efficient examples that has been previously mentioned as a proof of the EU law in action. Many have the perception of it being a direct interference of the autonomous legal system of member states.